Matter of Zamora. Counsel, you want some rebuttal time?
Yes, I'd like to reserve 1 minute of my 7 minutes.
One of your 7 minutes. Okay. You got it.
May it please the Court, the decision of the Appellate Division in this case should be reversed because it conflicts with fundamental principles of the Workers' Compensation Board in at least two respects. First, by requiring the Board to draw a particular inference, the Appellate Division interfered with the fact-finding authority that the statute vests in the Workers' Compensation Board.
Shift the burden here? Did it shift the burden?
In effect, they do, yes. They said that there was this mandatory inference that the Board had to apply and that the employer had a corresponding burden of rebuttal. Neither of those, neither the presumption nor the burden of rebuttal is provided for in the statute. That is a judicial creation.
They said it depended on whether the worker had retired or not?
Yes, that's true. This line of cases
Is it possible, as you understand it, to be retired and or not to be retired and still have an attachment to the labor? I mean, is there such a thing as a non-retired employee who's not attached to the labor market?
Honestly, I think that's one problem with this line of cases, is that distinction is very hard to understand. And we think that, although actually in this case the Appellate Division said that the inference applies whether or not the employee is retired, it stems originally from a line of Appellate Division cases which can find the inference to so-called.
So as you read, this case eliminates the distinction essentially in favor of the worker.
Correct.
And you say we should eliminate it the other way?
We think there should be no required inference that the Board is required to draw. These are all fact-finding.
No inference of what? What's the – can you just elaborate a little what you're asking us to find?
These are partially disabled claimants, and the Appellate Division has said that there is an inference that their loss of wages for which they're entitled to compensation is causally related to the injury that caused them.
What are you asking? Are you asking us to find that they have to show they still have an attachment to the labor market?
Correct. Yes. Well, that's right.
Or permanent partial disability.
Or permanent partial disability. We think that's always been the rule.
Isn't that inconsistent with those insanity cases? Someone's on disability goes insane, goes into a mental hospital and still gets his benefits?
Well, clearly those are special situations where someone cannot look for work. What we're talking about here are otherwise healthy people, people who have.
Is the operative term involuntary? Is that what this is about? That you're involuntarily out of the withdrawn from the market?
That's right. That's right.
Whether you're retired or not retired, that you're involuntary?
Correct. And the theory that the claimant advances is that as long as you left your original job involuntarily, then you no longer have to show that you're trying to find some other kind of work that you can do.
Yeah, but here, this is not a straight situation when the person just left and is not looking for anything, never looked or whatever. The person did try a couple of other jobs, right, asked for lighter duty. Doesn't that change if you look at this case by case? Isn't that a fairly compelling case that this just isn't something where they're not looking for work or not trying?
Well, in this particular case, it's true the claimant made some efforts to look for a job.
But isn't that important?
It is important, but the Workers' Compensation Board felt that those efforts didn't really amount to a bona fide job search.
I have to go back to English because this Workers' Compensation Board language sometimes gets me. All we're saying here is that if you have a permanent partial disability, which she apparently has, you've got to look for work. And if you don't look for work, you're not going to get your comp benefits because you didn't look for work.
That's absolutely correct.
And the Appellate Division said, as I think you just said, well, she's permanently partially disabled, therefore she's entitled to her benefits, and no one has shown that she could work somewhere else. You're saying it's her burden to show that she tried to work somewhere else and couldn't. And having failed to do that, at least the board said she didn't meet her obligation there, that therefore they should be affirmed.
Correct. Correct. The Appellate Division said as long as you leave your initial job, I mean, someone might be in a situation where they have an injury where they can't do heavy lifting of some sort. So they may not be able to do a job that involves heavy lifting. But they're still capable of doing some other work. That's what partially disabled means.
But in this case, didn't the worker ask for lighter duty? I mean, is this so black and white as you're portraying it?
I think in this case, she looked for some jobs where the board thought that the only jobs she had looked for were jobs that she knew she couldn't do, and that if she had made a more extensive search, she might have been able to find something.
You're not saying this is black or white. You just say when it's a shade of gray, it's up to the board to call it.
Correct.
The dissent here. Oh, I'm sorry.
Go ahead.
The dissent made a distinction between involuntarily retired and voluntarily withdrawn. Do we have to make that distinction in order for you to prevail?
No, I don't think so here, because I think the point is that whether or not this person is retired or not retired, they still had a duty to, had the burden in order to establish their claim for benefits to show that they had made a search for, that they were still, quote, attached to the labor market. They were still seeking work that they could do given their physical limitations.
The key here is that it's a partial disability versus a total disability.
Correct. It's already been established, at least in terms of her medical condition, that she is capable of working, of doing something productive. And the only question is here is whether she has to find that type of work in order to continue.
Where does this concept come from, as far as the workman's compensation area is concerned, of being required to search for work?
Well,
is that in the statute? What does that come from?
The statute says that the employer is required to provide compensation for disability that results from a workplace accident. So there's this implicit causal relationship between the initial accident and the loss of wages for which they're receiving.
It's really a gloss on the statute. Starting back in the 1920s, I guess, we read this requirement in. It's not really in there in so many words, is it?
No, it's not in so many words. The workers' compensation law does not.
What about Section 15(5)(a), which looks to me like it says that when somebody doesn't have a job, you have to fix his earning capacity up to 75% of what his wages. Whatever happened to that statute? It's in the statute book. I don't see anybody ever applying it.
Well, the statute says that if they have no actual earnings, their loss of wage earning capacity can be determined on the basis of, quote, other evidence.
Not can be. It must be, doesn't it?
Must be. And so, which is typically a medical assessment of their actual physical impairment, if that's all you have. But the point is that's never more than a rough estimate. It's unless.
To me, what the statute seems to me to say is if somebody is not making as much as he or she could make, then you're supposed to figure out how much he or she could make. What the cases for the last 80 or 90 years seem to say is if you're not doing your best, you're out of luck. How are those consistent?
Well, because you've broken that causal relationship. If you're not trying to find some work you can do, then your loss of earnings is not attributable to the injury that
but the statute is directed at someone who's earning less than his or her earning capacity. Isn't that by definition? Isn't that the very situation you just described?
Yes, it is. But the fact that they are earning less than they were before, I mean, that's only part of the equation. It has to be attributable. That loss of wage earning has to be attributable to the accident.
Okay,
that is the basis of the
okay. You'll have whatever it is, the 1 minute. Counsel?
Thank you, Your Honor.
You want to take any of your 3 minutes?
No, I'm going to just use my 3
Okay,
minutes.
just let her rip. Go ahead.
Perfect. Thank you. Michael Becchione on behalf of New York Neurological Associates. It's our position that the appellate division's decision should be reversed because they based their decision on the wrong standard. They based their decision on the standard in involuntary retirement cases, and this is not such a case.
What is, and I'll ask you the same question, what is the difference between a worker who is retired and a worker who is not retired but is not attached to the labor market?
I think the courts define it as somebody who's in the labor market who is still trying to get employment as opposed to somebody who has ceased.
Well, no, you mean if you're in the labor market and still trying to get employment, then you can be not attached to the labor market?
Correct. That's the way the courts have made that decision. Somebody who still has not removed himself, who might be desire.
You're trying to get a job, but you're not attached to the labor market?
Well, somebody is like what happened here. She did try to get a job after working for New York Neurological Associates. She went to work for Cornell Hospital, then Queens Hospital. It was thereafter that she did not retire, but she did not make any efforts according to the Workers' Compensation
Okay, well, that's what I get at. How do you know whether someone has just retired or stopped making efforts? What's the difference?
That's a good question. When somebody's just
Anybody got an answer?
I mean, because the courts really don't describe. There's no such official description, either statutory or in the case of.
Aren't you really saying that the distinction that the Third Department has drawn in these cases just doesn't work?
I don't think it exists in the law. You know, it's 15, as you were saying about Section 15, it says that the board, when somebody's not working, has to somehow create a earning capacity for them, and they should do it through medical issues and also vocational issues. They've got away from the vocational issues.
But your view in answer to the question that the parent asked before is then it makes all the difference whether you're actually retired or whatever this definition of this other state that you're in. That makes a difference because what they applied is to the person actually retired. Is that your position?
Well, according to the appellate division case law, yes. They have two sets of cases. They have the involuntary retirement cases where they say someone doesn't have to look for work to get the inference that they have a causally wage.
So your view, and even if you can't define exactly what you have to do or don't have to do to be in that second category, once you're in there, this other line of cases apply?
The other line of cases say that you do have to look for work to get that inference of causally related wage loss. And if you don't get the inference, then you should be denied benefits.
As long as you're not retired.
As long as you're not retired.
So if you're retired, you don't have to look for work. But if you do, but if you're not retired, you do have to look for work. So can you just stand up and say, hey, I'm retired?
Well, it's not just retired. You have to put the word involuntary in front of retired. If you're involuntarily retired, according to the line of cases, then you get an inference of causally related wage loss, which must be rebutted.
But what if you involuntarily stop looking? Well, that's what as a result, suppose motivated by your disability, you stop looking for work. Is that retirement?
In my mind, it wouldn't be, and you'd have to, you know, if you're still out there and still able to work, you should try to minimize your loss.
And in this case, what happened?
Well, she said she left her initial job because of pain. She then went back to work for 2 jobs. She alleged that she was trying to find work, so she was still in the labor market, but the Workers' Compensation Board found her search for work to be insufficient. In other words, that it was a search for work just to meet a burden as opposed to a sincere search for work.
Okay.
Thank you.
Thanks, counsel.
Thank you.
May it please the Court, I'd like to start with Judge Piggott's plain English point and then hopefully satisfy some of Judge Smith's questions. I think it's important for the Court to start here with the concept of what partial disability is in the workers' compensation system. If you have a worker who's earning $1,200 a week before the accident, and the Workers' Compensation Board finds that that worker has a moderate partial disability, what the board is saying is that that worker has lost 50% of their wage earning capacity, and that this person who formerly earned $1,200 a week can now only earn $600 a week. The compensation that's paid to the worker is 2/3 of what they've lost. So they will be paid $400 a week, which is 2/3 of the $600 a week that they can no longer earn.
How long do they get paid now?
On the facts of this case, that would continue for as long as the disability continued. If it's a permanent disability, it would continue for life.
Where does the $600 come from? Is that what the worker is actually making in an alternative employment, or is that a number that the board figures out?
The board, as you pointed out under 15.5a, must fix a wage earning capacity for a partially disabled worker. So if they find that there's a 50...
Well, actually, 15.5a says for one who's making nothing, you fix a wage earning capacity.
Yes, that's what I'm talking about.
Okay, so we're talking about only partially disabled people who are totally unemployed?
Yes, sir. So if they have a 50% wage earning capacity, then they have a $600 loss from their average weekly wage of $1,200.
Okay, but wouldn't the prima facie, if you said here's somebody who's totally unemployed and only partially disabled, maybe that's because he or she can't find a job?
Yes, and I intend to get there. But for the time being, the point that I'm endeavoring to make is that the person is only being compensated for the 50% of their wage earning capacity that they have lost. The argument that the board is advancing here is that if the person does not go out and attempt to earn the other $600 a week that the board has determined they might be able to earn, that the payments that they're getting for what they cannot do should be taken away from them. So the construct that the court is being presented with here by the board is a punitive construct.
Well, but the board does that. I mean, we can't, we're not here asked to change that, are we? I mean, I thought the debate here is the Workers' Compensation Board said you applied for 3 jobs. I'm putting words in their mouth. You didn't qualify for it. You can't lift 30 pounds. You shouldn't have even applied for that. You know, whatever's going on at Cornell or the other places. Those are phony applications. I'm being harsh. And on top of that, all you did is put your resume on the Internet, and now you say, you know, you've looked for work and you can't do it. We're not buying it. Therefore, we're going to take away your benefits. Well, it gets to the appellate division, and that's where the debate here is, I thought, where the majority says that she prima facie can't get her work because she's disabled, and the dissent is saying, no, she has to demonstrate that she looked for work. The burden was on her in that instance, and she didn't meet that burden. Right?
And that, Your Honor, is precisely the question, is when does the burden come into existence?
Right.
And for 80 years, the burden did not come into existence for a permanently partially disabled worker unless there was a finding that there was no connection whatsoever between their separation from employment and their compensable disability.
Because the dissent cited Peck, Stevenson, and Johnson. All what they say is that the burden was on the employee.
In Peck and Roth and Hare,
but they're all within 10 years. I mean,
what you will, yes, this is a new development in the last 10 years. But what you will find in those cases is that the board in Peck and in Hare and in Roth never made a determination whether the claimant stopped work because of the compensable disability. The board in those cases evaded the question. In this case, the board specifically found that Ms. Zamora stopped work because of her compensable injuries. And if you look at the record, you will find that early on in the case she was in work and out of work and she tried to go back and could not.
So once they find that, what's the consequence?
Under a long line of cases that goes back to the Roberts case in 1957, if the claimant stops work because of her compensable disability and she has a partial disability, she's entitled to compensation for the portion of her wage earning capacity that she has lost.
Does it matter what her status is?
It does not matter.
Retired, not retired, involuntary.
It does not matter what her status is.
Even if she goes to Florida, and it does nothing but lie on the beach for the rest of her life, she still gets it.
Yes, Your Honor. That is the law that has been set down by the appellate division and upheld by this Court.
You say Roberts says this?
Pardon?
That's what Roberts says in your view?
Roberts sets up what happened in Roberts is that the claimant had a partial disability and worked with no wage loss with that disability for a decade.
Okay. What case deals with my lady in Florida? What case says that
I would point out to you the Papkoff case, which you referenced, and which this Court cited and quoted in the Tellini case.
The two insane people cases.
We find no basis in authority or in reason for appellant's unqualified conclusion that a claimant may not collect payments awarded to him for permanent partial disability.
You suggest there's no real difference between being in an insane asylum and on the beach, and I see the point. But do you have one where the person is literally on the beach, or is just relaxing and still gets a partial disability?
Well, in this case, Your Honor, the claimant, as was pointed out, looked for work and ended up on welfare because she could not find a job.
Okay, but that's a possible view of the facts, but I gather it's not the view the board took.
The view that the board takes and the view that the board argues on this appeal is that where you have a partial disability, if you do not exercise what we, the board, feel your remaining earning capacity is, then we will not pay you for that which you have lost. And in our view, that's punitive and unwarranted.
I take it the board is saying that if you have a permanent partial disability, there's an ongoing obligation to attempt to find employment that you're capable of doing.
Yes, Your Honor.
You're saying that you can declare yourself retired, and then your benefits continue forever, that there is no ongoing obligation.
Well, the line of cases that the board cites for its proposition are the line of
Can
cases.
you answer my question? I'm trying to figure out.
I'm saying there's no authority for the board's proposition, yes.
You're saying it's the 50...
So there's no ongoing obligation to look for employment that you're capable of performing. That's your position.
There are two circumstances under which that obligation exists.
Just one caveat. As it relates to that 50% is what you're saying, that you lost.
Yes.
Okay,
Yes.
go ahead.
But the two circumstances where the board is correct is in the line of cases that goes back to 1920, which is Jordan and Zink and Bellow and Becker, and continuing on with Doberstein and Perilla. If the claimant is alleging that they have a total industrial disability, then the courts have held that the claimant must unsuccessfully look for work in order to prove that they have no wage earning capacity. That is not the claim here. The other line of cases is where as in Roberts, the claimant left work for reasons that had nothing to do with the disability, and then wants to claim compensation. It now becomes the claimant's burden of proof to show that the compensable disability is impacting on his wage earning capacity, since the facts had established that it did not.
I guess where I'm having great confusion is there any incentive for anyone who's declared permanently partially disabled to look for any employment that they may be capable of doing?
Yes, Your Honor, and that incentive is built right into the statute. To go back to my example, if the claimant has a $1,200 average weekly wage and is found to have a 50% disability, they're being paid for a loss of $600, and the board has found that they have the ability to earn $600. That claimant has every incentive in the world to go back and try to earn the amount of money that they're capable of earning, because then they will get reduced earnings under the statute.
Before you lose your time, in this case, she applied to Cornell and to a surgical unit, I think, somewhere, and to this airline, and was found not to be able to do any of that work. And then the board says, and all you did was put your resume on the Internet, and we don't think that's enough. Did the board err in saying that?
Well, the problem, Judge, with the board standard is that there is no statutory or regulatory guidance for this. This principle does not exist in the workers' compensation law.
What should they have said? Even though you applied for jobs you weren't qualified for, and even though you only put your resume on the Internet, we still think you ought to get paid?
The board found that she left work because of her injuries, and when she went back to work during periods at a reduction in earnings, she was, to go back to your question, she was paid more weekly than she would have been paid.
Your answer is yes, isn't it? Your answer is yes to Judge Pickett, right?
If I didn't understand the question and you do, then I'll agree with your answer.
Good choice.
He's saying, assume that your client made no good faith attempt to get work. She's still entitled to her partial disability.
And she'd be paid based on disability rather than actual earnings. And that's the answer to your question, is the availability of compensation calculated based on actual earnings instead of the board's estimate is an incentive.
If I'm happy with the $600 a month, and I decide I don't need a week, and I decide I don't need the $1,200 a week, then your position would be I don't have to look for work and I can just get the $600 a week, right?
You're not asking the carrier.
Go to the beach and judge.
You're not asking the carrier to pay you for what you're able to do. They're simply paying you for what you've lost. And again, none of this is anywhere in the statute, as Judge Smith has observed.
Okay. Thanks, counsel.
Thank you.
Counsel, why shouldn't you be able to go to the beach in that situation where, the way your adversary describes it, you're basically compensated for that 50% that you can't do?
Well, because that 50%, if the person hasn't looked for work, that 50% is based on basically a medical assessment, and that's all you know.
Yeah, but you found them, but let's say you found them, which is the situation here. Let's say you found them permanently, partially disabled for 50%. Why shouldn't they be compensated for that 50%?
Because that 50%, there's no way of knowing whether that is an accurate measure of their loss of wage earning capacity.
Can I try English again? Let's assume you got somebody that lose their little finger. So they have a permanent partial disability, right? Mm-hmm. All right, and they're a secretary. They like being a secretary. They can't be a secretary anymore because they can't type as fast as they used to. So they say, okay, you know, I'm going to the beach. I guess that's where we're sending our injured workers now. And aren't they entitled to their permanent partial disability payment?
No, because I think they may be able to find work as, say, a receptionist.
So if you said, yeah, you can be a receptionist or a paralegal, then you lose the permanent partial disability benefit, even though you're still permanently partially disabled.
If in fact your wage earning capacity has not been impaired because working with your disability you are actually able to make as much as you were before.
Well, suppose it has been impaired, but you could still find employment. You could find less remunerative employment, but you don't want to. You want to you want to relax a little bit. You've lost a finger. You want to console yourself with your grandchildren. Why not? Why shouldn't you still get your partial disability?
Well, because that's always been the policy of the statute. Is it goes back to Jordan. And I mean, in Jordan, that case, Justice Cardozo said the famous line about sloth is not to be at a profit. I mean, there the employee, he was doing work, he had a back injury, or he had some kind of an injury that said he couldn't do heavy lifting anymore. So he wasn't able to do that work, but he was able to do other work like being a night watchman. And he was denied benefits because he didn't take that lighter work that didn't involve the heavier burden. So right at the very early years of this statute, this court found that this was an important policy in the law, and it's never wavered.
But in the common sense perspective that Judge Piggott keeps talking about, does that make sense that there's so many things you see in our world that we live in today where the person is disabled and goes out on some kind of disability payments and it's recognized or whatever, that they couldn't do the job they used to do, or in this case, in examples we've been using, let's say part of the job, 50% disabled for the job that you used to do. Why is that not fair?
Well, because if a person...
Or is it not fair, but it doesn't matter?
Well, no, I think it's totally fair.
Why is it? Why?
It's fair.
Why is it fair?
Because it's fair to say that people who are receiving benefits at a cost to all the other workers in the system ought to exert a reasonable effort to work to the extent they can. Because there are obviously going to be a lot of situations where a person may be disabled from a physically demanding job, but in today's economy, they can get a job where they don't have those same physical demands, and there's no reason why they should, say, lie on the beach at the expense of the workers' compensation system.
Okay. Thanks, counsel. Thank you both.